Okay, the appellant may proceed whenever you're ready.
Thank you, Your Honor. May it please the Court, I'm John Winnie. I represent Lee May. I would like to reserve 5 minutes.
You proceed.
Your Honor, this case, there's a couple, excuse me, the case arose out of a complaint that had been filed, and in the first count, the plaintiff alleged that there was an express oral contract. The second, and they attached a portion, he said it was partly written and it was partly oral. He attached an authorization to perform services to that count. In count 2, he alleged that there was an open account between the people, and of course the Court knows what an open account is, a series of transactions and debits between the two people that results in an account. Prior to the case, prior to the case being tried, I went to the trial judge and I stated my objection that this case is being tried. We had a different judge than the judge that had been sitting all the way along on the case. So I raised the objection to the trial court that it would be, the case was listed to be tried as an oral contract, and my concern was, after having read the case, in particular Schipani, that I entered into the brief and that you've probably read at this point, that I would not be consenting to a recovery under any other theory that may come in because the evidence is so closely intertwined. You hire somebody, you don't agree on a set price, then...
You're talking about any other theory other than the two that were pled.
Exactly, Your Honor. And they did not plead quantum merit, they did not plead unjust enrichment, they did not plead a contract implied in fact, they did not treat a contract implied in law. They pled that there was an oral contract. Well, why does it make a real big difference? Well, it really makes a great big difference in terms of the following thing. This Court has defined oral contracts as a contract where all the essential terms have been agreed on between the parties, and there are no material terms or essential terms left open. And that was this Court in W.R. Townsend, 728 Southern 2nd, 297. And since they came there pleading a oral contract, obviously the danger lurks that you go through this, as in the Schipani case, the trial judge presents it to a jury, oh, well, you didn't prove your contract, but I'm going to let you prevail on another theory. So during the evidence of the case in chief of the appellee, it was absolutely clear, because of the testimony that I cited in my brief, that he had reserved unto himself the ability to charge whatever he wanted. He said that he said in his testimony that I cited, he didn't know how he was going to charge, and he left it open. The important point is, first of all, the attachment to the complaint. He attached two documents. The first one was what he said were the written terms of the oral agreement. So he said that there were written terms and express terms as well. And under the open account, he attached an invoice. Well, it's important to note that the judge would not let that invoice in, and he made a directed verdict against the open account on the theory that he hadn't proved an open account. The invoice clearly shows that there was no account between these parties, that no debits and credits or anything that had ever arose, and the judge directed a verdict. At that time, the appellee, after the case in chief, seeing that the oral contract was out the window, made his motion to amend his pleadings to state a case in quantum merit, which would allow the plaintiff to collect for whatever it is that the law would find would be reasonable for his services.
Mr. Winnie, maybe I'm missing something, but didn't the jury return a special interrogatory verdict that actually found that a contract existed?
Yes, they did.
And so what does quantum merit have to do with any of this?
If you look at the jury instruction that the court amended the oral contract, where you have to have a meeting of the minds on every essential term, and then the court stated in the instruction to the jury, which has been cited as an error in the briefs as well, then the courts amended an oral contract to say, okay, where the parties do not agree on a price, the law will imply a reasonable price.
Well, isn't that a standard provision of contract law?
It's a standard provision of in contracts implied in fact.
No, isn't it a standard provision of contract law generally?
The contract law encompasses contracts implied in law, implied in fact. It is a standard of contract law, but not express contract.
So you're saying if you have all the other terms of a contract expressed in a writing, let's say, I know yours is oral, but you have all the terms of a contract expressed in writing, except the price.
Right.
And you're saying that as a result of that, no contract was ever formed.
No, in my brief I said there's a contract implied in fact.
But there's no express contract
Exactly.
ever formed.
Exactly. Because
There's no rule of contract law that says if all of the essential terms except the price are agreed upon, it will be understood that a reasonable price was intended.
Sure. In contract law, they do say that, but they say that that is a contract implied in fact.
You refer to the Chappelle case, McGill versus Cockrell, I think you mean?
Yes.
About the widow and the Jacksonville case from 1924?
Yes.
They clearly did not, the lawyers and the widow in that case did not agree on a price.
Well, that's true.
And yet the court said the law firm was entitled to an award based on a reasonable price attributed to the services, which is not quantum merit.
And if they had pled an alternate theory in this case, we would have come to the same result.
But does McGill talk about a contract in fact?
No. The contract...
It says a contract existed.
It's 80 years ago. It didn't specifically say that this is a contract implied in fact. It says it's contract. Well, that certainly is true. Every implied in fact contract is a contract. But I'd like to point out...
If I plead that I have entered a contract with somebody, isn't that what a contract in fact is? Are you saying that the complaint has to say breach of contract in fact, not just breach of contract?
The contract has to say that you'd have to allege the elements of implied in fact contract, okay? You wouldn't allege that you had an express contract. You would just allege the facts and ask for the relief.
I guess what I'm asking is, under the law, is there any difference between an express contract missing the term of a reasonable price and an implied in fact contract? Because, for example, here, you certainly have every element of a contract in fact, even if you were right about the express contract not existing.
Of course. And if they pled a contract implied in fact...
But how are you prejudiced in any way by that?
If you read Schipani, the facts of the case were the defendant, the plaintiff in the case, did some work on a contract that he believed would pay him, okay? The judge ruled there wasn't an express contract. The judge ruled that there was an implied in fact contract, and by the way, there was an implied in law contract. The District Court of Appeals said, no, you can't do that. The judge in the case said, you have to declare the horse you ride in on. You can't ride the express horse in and then ride the implied horse out. Okay? That's what the judge said. Now, back to McGill for a second, because I don't want to leave that. In McGill, the issue was whether or not the writing that transpired between the letter, by the letter from the defendant in the case, constituted a sufficient evidence that would extend the statute of limitations for 2 years. Right. And that's what the case was about. The fact that it didn't use the word, it wasn't a fact about what
You're saying the comment about contract is dicta?
Yes. Yes. They had it when they had the written part. And
but there was no price in that writing.
No, and there's a lot of contract implied in facts that you'll read the cases, and the cases say, well, there is a contract, but the issue here is what you have to plead. The issue here is Archie. The issue here is all the cases that follow from Archie. The cases that follow from Archie say, and I quote the Supreme Court on it, say that in this day and time, to protect and preserve judicial time, that one has to state in one time, in particular, what it is your theory of relief is. You can't, here's the big difference, and let me just make this clear. If I'm going in there to defend a contract case, I have to meet, I'm defending a case where they have to meet on all the essential terms, okay? I cited the cases in my brief. The price is always an essential term of an express contract. If he's going to allege he's got an express contract and not allege that he's coming in under quantum merit or unjust enrichment, he has to prove the express contract. If he doesn't prove an express contract, he doesn't get the benefit of the contract, okay? He has to plead the implied contract. He didn't plead the implied contract. Excuse me. So not having pled it, when we got to jury instructions, the court amended the standard jury instruction for a contract. Now, the ones normally that people have, I took the federal standard contract as its proposed jury instruction. The court amended that. And at this point, the court amended that to say where there is no price, folks, after a meeting of the minds. The part that says you have to have a meeting of minds on every essential part of the contract. After that, in the jury instruction, the court amended it and added the language, well, if they don't agree on price, the court will, excuse me, if they don't agree on price, the law infers a price.
But that's not what the instruction said. What the instruction said is if the contract doesn't fix a price, it's presumed that a reasonable price was what they agreed to.
Exactly, and that's an implied in fact contract. An implied in fact contract, by definition, is where two parties agree to a contract, and they don't agree as to the essential price term, and then you have a contract that's implied in fact. The Schiappani said, we're not going to let you recover if you don't plead it. Archie, in all the cases, said if it's an unpled theory, you can't recover on it. You have to state up front which horse you're going to ride. If you're going to ride an express contract, go all the way.
I don't know if you saved any time for rebuttal, but you're down below 3 minutes.
Okay, well, let me just say real quickly, because the contract was alluded to be an express contract, I knew he had to prove an express contract. I knew from the case law it said, and the price is an essential part of every contract. That's what the case law said. I knew that under the standard and jury instructions, they would not be able to prove that they ever had a meeting of the minds on that price. Okay? So why did the judge rule out that he couldn't recover in quantum merit at the time, and then change the jury instruction to allow him the equivalent of quantum merit? I'll reserve the rest of the time.
Good afternoon. May it please the Court. I'm David Weiner. I'm here on behalf of Appellee Octi-Dry Industries, Inc. I don't know whether, given the argument by appellant, whether you all have any specific questions for me. And if not, I was just going to address all four of the appellate issues as they were addressed by appellant in her briefs. And as to issue number one, it is our position, obviously, that the trial court did not commit reversible error in refusing to grant a directed verdict as to plaintiff appellee's breach of contract claim.
Well, your position, at least your first position on that issue, is simply that it wasn't preserved.
Correct, and I believe that that is the accurate and that's based on the fact that according to the Murello v. Mark Andrew of the Palm Beaches case, which I cited to this Court, the standard for not, essentially the excuse for not having to preserve that issue for appeal by renewing the motion at the close of the evidence is, and this is a quote from that case, where the insufficiency of the evidence constitutes plain error apparent on the face of the record, which, if not noticed, will result in a manifest miscarriage of justice. That's not the situation here. In her reply brief, appellant addresses this argument by quoting pages 242 and 243 of the record. And this is a question by Mr. Winnie. He says to Mr. Bass, so you hadn't figured it out that you never had an agreement with Mrs. May how you were going to charge for this job, did you? Answer, no, sir. And from there he goes on to make his argument. I would implore the court to go back and read it. This is what it says. This is the full answer. Answer, no, sir, my main concern. Question, okay, thank you, I'll accept that. Answer, no, sir, my main concern was, question now, answer, to give her something she could get reimbursed for. Now, 10 pages later, actually it's 8 pages later, on page 250, line 19 of the record, Mr. Bass also testified when being cross-examined by Mr. Winnie. This is a question by Mr. Winnie. You never had an agreement based on an hourly amount with Mrs. May or Rhonda Darris, did you? Answer, yes and no. We had an agreement to perform services, and we had an agreement to charge her either by the hour or by unit pricing. However, at that time, we didn't know what unit pricing might entail. Our promise to her was to give her the most economical price so that she could get reimbursed by her insurance company. Obviously, based on Bass's testimony, the jury could have and did find that the parties had an agreement for the appellee to do the work and bill either by time or by unit pricing, whichever was the most economical, and that was the testimony. Was that he, and there's actually some more, and I believe it's on the record at page 100 and 101, where he talks about how the agreement was that they were going to use whatever prices were given by the insurance guidelines because that's what was published. So it was reasonable, and my client testified that that was what he used. So either by failure to preserve the issue, by failing to renew the motion at the close of the evidence, or by the sufficiency of the evidence to outright deny based on Mr. Bass's testimony, the trial court was correct as to issue number 1 in denying the motion for directed verdict that the appellant has brought forth to this court. Now, as to issue number 2, the trial court did not err in its instruction to the jury. And Judge Webster, I'm so glad that you brought up the actual instruction. And if Judges Wolf and Thomas, if y'all haven't already gone back and read the instruction, it begins page 591, line 11 of the supplemental transcript. It's kind of long. I don't want to read the whole thing here, but I do want to bring out a couple of points. This is from page 592, line 3, and this is a quote. A contract to be binding must include a manifestation of mutual assent to the terms and conditions of the contract. This is referred to as a meeting of the minds. There can be no contract if only one party intends to be bound. Line 20 of the same page. In determining whether or not there was any contract, you must decide whether or not there was a meeting of the minds between the parties with respect to the terms of the alleged oral agreement and present intention to be bound. When a contract fails to fix a price, a reasonable price is implied by law. And finally, and this is from page 594, line 10, if a controversy resolves itself into a situation where the parties meant and intended one thing and the other meant another thing, it is manifest that the first element of the contract, that is, the mutual meeting of the minds, is lacking and there is no contract. That's what the jury was asked to go back there and figure out whether there was a meeting of the minds, and they came back in 7 minutes saying there was a meeting of the minds, pay the man or pay the company. And this instruction, if you go back and read it, is a far cry from the issue as framed by appellant in her brief, and this is a quote from the brief. The jury, the trial court instructed, and this is the quote, the jury, they could ignore whether or not the parties had a meeting of the minds as to the price of plaintiff's services and award appellee a reasonable value for those services. That's end quote. The instruction is an accurate statement of the law per the McGill-Cockrell case. And if y'all go back at page 4 of the reply brief, appellant attempts to neutralize McGill by stating, and this gets a little confusing, but this is a quote from her brief with some little quotes in between. But the quote is, appellee misconstrues the meaning, quote, implied assumption, end quote, as used by the court in holding that recovery was not based on, quote, quantum merit upon implied assumption for services performed, end quote. The court was stating that it was not finding a contract implied on law, but rather upon the, quote, express assumption of a contract implied in fact upon the express written request of the party for the services rendered. But the key is this. Despite the implications of appellant's brief, the terms implied assumption, the phrase quantum merit on the implied assumption for services performed, and the term express assumption never appear in McGill. The law of McGill is where a contract fails to fix a price, a reasonable price implied by law, which makes sense. Now,
So your argument is if I retain someone to perform lawn service on my lawn all summer long, and the lawn service provider says, I'm not sure what the price will be, I'll give you the best price from your perspective, and I say that'd be good, whether you charge by the hour or the service. We say we don't figure out whether he or she's going to be paid by the hour or the occasion. Then you say that the lawn person is entitled to a jury instruction that even though we never agreed on a price, we have a contract and the jury can just plug in a reasonable price.
No, sir, I don't think that's what I'm arguing. What I think the law is that, and let me get to your example.
Your argument, though, is that is an express contract.
It is an express contract, but also keep in mind the situation that these parties faced here. This is a situation where...
I'm asking about my hypothetical.
Yes, sir. Okay. Under your hypothetical, yes, it is a contract. However, I believe that the problem that is presented there is that first of all, there's no emergency situation. You don't need...
Forget that. Under my hypothetical...
Yes, sir.
I tell a yard service, please mow and take care of my yard and put in hundreds of hours taking care of it all summer. At the end of the summer, we'll get back together on price, and the lawn service says, yes, I'm not sure whether it's better for you if I charge you by the visit or by the hour. I'll give you the best price.
Yes, sir. That's a contract.
That's it. That's
Yes,
an
sir.
express contract, and the jury can just decide and hear evidence about value per hour, value per visit, and they can just plug in what is a reasonable amount.
Correct, Your Honor. And in this particular case, what the jury heard was that $65 an hour was the amount per the insurance guidelines that my client told Mrs. May before he began work that that's what they were going to charge for. So, but I do want to tack on one thing that it kind of distinguishes it. I don't want to belabor that point, but this is an emergency situation. And so I think a better analogy, although I like yours, is when you go to the ER or you go to the hospital, you sign a contract. You agree to be liable if your insurance company doesn't pay. Now, they don't give you a price list. Because they have no flipping idea what is going to be wrong with you when they open you up. All they know is that you're hurt. Well, in this particular case, my client arrives at the house, and there's, according to appellant and the people that were talking to my client and his people, there's $500,000 worth of clothes in the pool. Now, he doesn't know whether they're $5,000 items or $500. He doesn't know. So all he's saying is, whether it's per unit or per hour, I'm going to give you the best deal, but if you want me to try to save all these clothes, we got to get cracking.
Mr. Wayne?
Yes, sir.
Did you happen to think to look to see what, if anything, either the first or second restatements of contracts has to say on this issue?
No, sir, I did not.
It might have been a good place to start.
Yes, sir. Okay. Again, it is completely consistent with the court's instruction, the evidence presented to the jury, the verdict returned by the jury, that there was a contract and that it was reasonable. Now, interestingly, appellant quotes the Jim Broadcasting case in support of her theory that the theory that appellee actually prevailed upon was an unpled contract implied in fact. And the Jim quote supplied by appellant is as follows: a common form of contract implied in fact is where one party has performed services at the request of another without discussion of compensation. I'd agree with the Jim court. But what happened in our case, if you look at page 89 of the transcript, Lenny Bass testified about a lengthy discussion with appellant that included the topic of conversation. And the conversation ended with appellant stating, I will pay you, I have the money and the ability to pay you. And that's at page 91, line 5. The contract in this matter was not implied in fact. The trial court's instruction was not error. Now, as to issue number 3, the trial court did not err in awarding the prejudgment interest. My reading of her briefs is that appellant bases her argument on this issue on 2 premises. First, that the verdict of the jury was for an unliquidated value of appellee's services, and second, that appellee is seeking interest on monies that are not out of pocket. Both of these issues were addressed by the Lumbermans v. Pierceville court that we cited in our brief. The Lumbermen's Court affirmed the reasoning of the Supreme Court in Parker v. Brinson Construction, which was also cited in our brief, but here's the quote from Lumbermen's from Parker, and that is, "The fact that there's an honest and bona fide dispute as to whether the debt is actually due has no bearing on the question. The rule is that if it is finally determined that the debt is due, the person to whom it was due is entitled not only to payment of the principal of the debt, but to interest at the lawful rate from the date due thereof." Like appellant, the party in Lumbermen's also argued that to award the interest on the non-out-of-pocket expenses would result in a windfall. And the Lumbermen's Court found that argument, and this is a quote, and I've changed the names of the parties in here just to make it flow a little bit better, but the Lumbermen's Court found that argument, quote, "ignores the fact that it has a contract with the other party supported by consideration. Whether the other party uses to pay the money to pay the out-of-pocket expenses for some other purpose does not change the fact that debt has been created." And so in the instant case, the jury found there was a contract between the parties. The contract included the written document signed by appellant before appellee began work. And Lenny Bass testified that on December 12, 2007, he provided appellant an invoice in the amount of $22,273.80. The damages awarded appellee by the jury were $22,273.80, the entire amount claimed due as of December 12, 2007. The written portion of the contract provides that if Octi-Dry submits this account for collection, customer agrees to pay interest at 1.5% per month or the highest rate allowed by law, court costs, and reasonable attorney fees at all costs of collection. So Octi-Dry submitted the account for collection. Appellant was obligated to pay the contractual interest rate. According to Lumbermen's, the fact that the invoice amount included monies which appellee was not out of pocket is immaterial here. And finally, Your Honors, as to issue number 4, the trial court did not err when it determined that appellee was entitled to an award of attorney fees as a result of the prevailing on the breach of contract claim. And again, I would point the court back to that same portion of the contract which states that...
But there's been no award of attorney's fees here yet, has there?
There has been, yes, sir, actually there has. In the interim, the trial court...
But nobody sought to amend this appeal to include the actual award of fees.
No, sir.
So at this point, the attorney's fee issue is premature. The law is fairly clear that until an amount is actually awarded in attorney's fees, you don't have an appealable issue.
Okay. That's...
You'll
I
take
was going to say, you're getting a softball. Jump on it.
Okay, that's fine.
Works for you.
Yes, sir. That's fine. Thank you, Your Honors. That's all I have. Appreciate it. You'll have a good day.
May it please the Court, I would just respectfully like to say that the issue in this case is not whether or not there exists a contract implied in fact, which I said in my brief. The issue is whether or not you're compelled to plead it. I think the law is absolutely clear with Schipani and all of Archie and all the people that considered the issue. An implied contract, implied in fact, is a separate theory, even though some of the cases may say there is a contract and don't get into the issue of whether or not it's an implied contract, for example, McGill. Okay? And all the cases that were cited in my brief to the point is, the issue is whether or not he was compelled. The difference is, if he's going to come in and plead a contract, all of these terms that are in this document, there was a meeting of them, it have to be a meeting of the minds on everything, and all these terms are picked up in an essential contract. If there is no contract, the terms go away. But let me just make an observation. I'm running out of time on the prejudgment interest issue. You heard counsel say that he admits that there were no out-of-pocket expenses on the part of the plaintiff. It's stated in the brief. There was a long discussion with the trial judge. And the two requisites for prejudgment interest are the out-of-pocket damages, out-of-pocket expenses, and you also need to have a fixed date determined. He said the date December 12th. There is nothing in the transcript and nothing that he showed that showed anybody what day that the plaintiff, or excuse me, the appellant received a check from the insurance company. I turn your attention to authorization to perform services. It says, if for any reason the check should come or be made payable to the customer, customer agrees to pay Octi-Dry immediately upon receipt of the check. There was no evidence of any check ever been received. He says in his brief she got $250,000. He did not put on a case that to show when she received the check, that would trigger a date due, if there was a date due. So under...
So she got a check for 200, well, you're saying there's no evidence to support that. What the record is crystal clear on is your client has never, not once, submitted 1 penny in payment for the services, right? Right.
The record...
She never paid.
They haven't paid
She
because...
never paid the provider for the services.
Because it was disputed under the conditions of the trial. But the point is...
Okay, your time is run. Thank you very much.
Thank you, sir.